Welcome to USPTO Hour, the Trademarks edition. It is January 28th, 2026, and today we are fortunate to have as our guests members of the Trademark Trial and Appeal Board, often referred to as the TTAB. I'm Jason Lott, the managing attorney for Trademarks Customer Outreach, and it is my job to provide you with legal training in the field of trademarks. Whether you're a small business owner, a new lawyer, a paralegal, support staff, or maybe you're one of our experienced practitioners with decades in the field, we want to make sure that you have all of the knowledge and tools that you need in order to accomplish your trademark goals. So, uh, specifically, we want to make sure that you can submit the highest quality application that you can. And of course, we can help you avoid some trademark scams. So as you can see on the screen, we have a fantastic panel of experts for you today, including the Acting Chief Administrative Trademark Judge and the Acting Deputy Chief Administrative Trademark Judge. And I'm going to introduce them in just a moment. But before I do, I, of course, have to cover a couple of quick housekeeping items. In case any of you are wondering, is this session being recorded? The answer is yes. Yes, it is, and we're going to post the recording as soon as we can so you can come on back and watch it at your leisure. We did that with the May version of our USPTO Hour, which also featured the Trademark Trial and Appeal Board. That was part one, so you can go back and watch that whenever you want to. I'll grab a link and we'll try to throw it into the chat for you today. For those of you who are interested in a copy of the slides, yes, those will be available as well. They're not available at this moment, but we will make sure that those are also posted along with the recording so you can access them anytime you need. If you are someone who wants or needs captions, you have two options today. If you're okay with a robot giving you some captions, you can just use the little CC button down in the bottom left-hand corner of your screen. But if you're one of those folks who likes live human captions, you're going to find that in the chat box. That is down in the bottom right-hand corner of your screen. You're going to see the little chat bubble. You can go ahead and open that if you're interested. Our tech team is going to be throwing in the link to captions right in there, and that's where you'll get it. Thank you, Linda, who is providing our captions for today. The chat is also where you're going to be able to communicate with us today. So if you're having some sort of technical issue with WebEx, you can just post something into the chat and let our tech team know. They'll do their best to sort you out. Maybe there's an audio issue or some sort of video issue. Please feel free just to let the team know, and they will do their best to get things sorted for you. Honestly, folks, sometimes what happens if there's a weird audio thing, the best thing is to leave the WebEx and then come right back in, and it fixes it. I don't know. I'm not a tech person, but sometimes that works. All right, so if you have a substantive question based on our content today, you have something about the TTAB or some of the things that are being discussed that you want to ask, you can also use the chat for that. But I'm going to tell you, our panelists today are going to be focused on providing the PowerPoint presentation. They are not going to be in the chat, so there's not going to be any live back and forth today, but we are collecting your questions. We're going to sort them to see if there are any that would be beneficial for the entire audience with us today to hear an answer to. And if so, I'm going to ask the panel to answer those questions live on the air before we get out of here this afternoon. So I cannot guarantee that we're going to be able to cover everything that's in the chat box and answer every single one of your questions, but we're going to do our best to make sure that we get to as many as we can before the hour is up. Please note, if you are a person who has submitted a question and it doesn't get answered, please do not take it personally. There are some questions that we just simply cannot answer, especially if they're asking for legal advice. But we're going to do our best, okay? And we'll try to answer as many as we can and as broadly as we can before we go. All right, well, that is enough of our housekeeping. Let's get to it. It is my honor to introduce our speakers for today. We have Judge Christina Heber. She is the Acting Chief Administrative Trademark Judge of the Trademark Trial and Appeal Board, the TTAB. And in this role, she leads the TTAB as it hears and decides cases, including appeals of final refusals, oppositions to register, and petitions to cancel trademark registrations. She previously served as the Senior Counsel for Trademark Policy and Litigation in the Office of the Solicitor at the USPTO, helping defend decisions of the USPTO Director and the TTAB in cases before the Federal Circuit and the District Courts. And before joining the solicitor's office, she was in private practice at a large intellectual property firm in Washington, D.C., focusing on trademark and unfair competition matters. She received her JD from the George Washington University Law School and her undergraduate degree from Dartmouth College. We also have Judge Melanie K. Johnson. She's the acting deputy chief administrative trademark judge of the TTAB. She was appointed to the board in February of 2020, and she has had an active and varied career in IP law before she joined the USPTO. Thank you for being here, Melanie. These positions included the Office of the General Counsel at the U.S. Department of Health and Human Services and Senior Counsel for Trademark and Copyright Law at DuPont, where she was instrumental in creating the company's first brand protection center. She began her career as an IP litigator, as well as a law clerk to Judge Eric L. Clay of the U.S. Court of Appeals for the Sixth Circuit. She earned her bachelor's degree with honors from the University of Michigan, Ann Arbor, and her law degree from the Ohio State University College of Law. And rounding out the panel is Jill McCormick. She has been an interlocutory attorney with the TTAB since 2018, where she handles pretrial matters involving oppositions and cancellations, including contested motions and discovery conferences. And prior to joining the USPTO, she was a litigator in private practice, focusing on trademark and patent matters with a large law firm in Washington, D.C. She received her JD with honors from Cornell Law School and a BA in Latin from Brown University. All right, Jill, your honors, it is over to you. I'm going to be back at the end to see what questions we can answer for the folks. Please take it away.
Good afternoon, everyone. We're really pleased to be here to do a part two of our introduction to the Trademark Trial and Appeal Board. This is less of an introduction and more of an update session where we will be talking about our fiscal year 2025 statistics. We'll touch on our issuance of precedents, some citation issues and the use of artificial intelligence, some things that we're seeing at the board and some tips for you all. And then accelerated case resolution, our pretrial conference pilot program, and we'll at the end answer some of the questions that folks had from our May 28th session. And so to begin, Melanie is going to start us off with the statistics portion of our presentation. And then I will say a few words on a couple of the other subjects, and then we will turn it over to Jill McCormick for our ACR and pretrial conference portion. And with that, Judge Johnson.
Thank you, Acting Chief Judge Heber. Next slide, please. Okay, so a little bit about our TTAB workload. Our fiscal year, just to explain, goes from October 1 to September 30th. So for fiscal year 2025, which went from October 1, 2024 to September 30th, 2025, 33,391 filings were added to the TTAB's docket. Many of them, you can see on the screen, were extensions of time to oppose, but this also includes new appeals that were filed or new ex parte appeals, new trial cases, meaning oppositions and cancellations, and new concurrent use proceedings. Next slide. Now, as to the ex parte appeals, so fiscal year ending September 30th, 2025, we had 3,701 new appeals that were filed with the board. That's up more than 6% from fiscal year 2024. We issued 405 final decisions in ex parte appeals in fiscal year 2025, which is about 48 more than we issued in fiscal year 2024. Next slide. Now to our trial cases, oppositions and cancellations. For the fiscal year ending September 30th, 2025, new opposition proceedings filed with the board totaled 7,650. That's nearly 14% more than were filed in fiscal year 2024. As for cancellations, 2,897 cancellations were filed with the board at the end of fiscal year 2025. Those are numbers. That's over 17% more than fiscal year 2024. And as you can see, in our trial cases, we issued final decisions in 190 cases. That's about 3 more than we issued in fiscal year 2024. Now, when we look at all these stats, we have to consider staffing. At the end of fiscal year 2024, so on September 30th, 2024, we had 28 administrative trademark judges, and that includes the chief judge and the deputy chief judge. We had 19 interlocutory attorneys, which includes our managing interlocutory attorneys. A year later, at the end of fiscal year 2025, or on September 30th, 2025, we had 23 administrative trademark judges, including our acting chief judge and our acting deputy chief judge. As for interlocutory attorneys, by the end of fiscal year 2025, we had 16, including the managing interlocutory attorney. Currently, as of January 28th, 2026, we have 22 administrative trademark judges, including the acting chief judge and the acting deputy chief judge, and we have 16 interlocutory attorneys, including the managing interlocutory attorney. Now I'll turn the presentation back to Acting Chief Judge Heber.
Yes, as Judge Johnson was saying, we are operating with reduced staff and doing the best that we can to keep up with our increasing workload. And so one of the other statistics that I know that practitioners in particular are typically interested in hearing about is our precedential decisions. And so for those of you who are not familiar with the TTAB and precedential decisions, I will give you a little bit of background, and then we'll touch a little bit on how we designate and what we're looking to do going forward. So a TTAB opinion or decision that's issued as a precedent, it serves as controlling legal authority for attorneys and judges of the TTAB, determining later cases that involve the same issues. The TTAB and the agency, so this means trademark examination, generally must follow the decision's holding unless the precedent is distinguishable or until it's overruled. So we have a document on our website that explains our designation process for issuing decisions as precedential, and it states that an opinion or decision of the board may be designated as a precedent of the board if it establishes, alters, modifies, or clarifies a rule of law or a matter of agency policy, if it reinforces existing law or policy by demonstrating its application to a factual record different from those confronted previously, but likely to arise again. So it would be instructive in other cases. In other words, not every fact scenario warrants a precedent. Or it involves a legal or factual issue that's significant interest to the bar or substantial importance to the public generally, or to trademark owners or practitioners specifically. We engage in thorough internal review before deciding to designate a decision as a precedent of the board. It is resource intensive and time consuming. And so we have historically issued a good number of them, but there is no set number of yearly precedents. And the designation of a decision as a precedent should depend on the issues that arise in the cases and whether the manner in which they're addressed in the decision meet the criteria for precedential designation that I just mentioned. As many of you know, our cases typically are turning on the particular facts and the evidence in the record in the particular case. They apply established legal principles to those facts, which means that most of our decisions do not warrant precedential designation. We do seek to identify internally cases that we see as raising issues of first impression, that clarify or explain a point of law where there's been confusion or inconsistent application that account for changes in law or policy that result from, say, a new statute, a federal court decision, or a rule change. And I will say we have not had rule changes recently. Other things that we'd look for would be cases that involve topics that bar groups have suggested to us, or that involve an application of existing legal principles. Maybe we have a really old case, but now we get to apply those principles in the context of a new technology or commercial practices where an updated precedent might be useful. We are now being more selective in what we propose to issue as a precedent, making sure that we're adhering to our own policies and that we are mindful of our significantly reduced judge staff. We need our judges to be focusing on the business of the board, which is deciding your cases that are before us. And as I mentioned, the process of reviewing decisions for issuance as a precedent is time consuming and takes our judges away from that. So we're mindful of that time that judges and others must devote to the review process. We're also aware that the Federal Circuit, which is our primary reviewing court, and we are bound by their decisions, in recent years, they have been issuing more precedential decisions concerning issues of trademark registration. They have been clarifying legal tests. They have been restating principles that we have held in our cases. So there is less of a need for the TTAB to step in and say some of those things when we have a binding Federal Circuit precedent that already is saying them. And so that is why, if you're wondering why you have seen fewer precedents issued, for example, in 2025, these are some of the reasons. We also feel that more precedent for the sake of more generally is not going to be helpful to the board or to the bar. If there's too large a volume of precedential decisions that are touching on the same subject, we and honestly practitioners can't reasonably be expected to identify those which should control the future decisions. We also have to retain flexibility in applying the law to the facts of a particular case and be careful not to bind ourselves or the agency to a particular approach unless it's warranted. All of this said, we do want to hear from you. If you see a decision that we've issued that you think should be redesignated as a precedent because it meets the criteria for designation as a precedent, there's a way for you to let us know. We have a form, it's an online form that's available on our website for you to nominate any non-precedential decision for redesignation as precedential. It's maybe not the easiest to find, so what I would suggest that you do is if you're on the PTO homepage, you can type in TTAB precedent nomination in the search bar, and the first result should pop up that takes you to the page where you can find this form. It's available on our policy and guidance resources page under decision information. If you do choose to submit a request to designate a decision as precedential, be sure to include an explanation of why you think the decision should be a precedent. Because we might determine in our discretion that the particular decision you're asking be redesignated is not appropriate to be redesignated. Sometimes there's, the point for which you want it redesignated is fine, but there's other issues with the decision. And so we would, in that case, generally not redesignate it. However, if you tell us why and what the issue is and why you think it would be helpful to have a precedent on that topic, then that issue will be on our radar for us to consider as a potential precedent if it arises in cases in the future. I also do want to, just manage expectations that if you nominate a decision, it does not mean it will be redesignated. The decision always will need to meet the criteria for precedential designation, and it has to be written in a form that lends itself to use as a precedent. So that's all I have to say on precedents. And now I will turn to our next topic, which is fictitious citations and the use of AI. And here I'm going to talk a little bit about, so next slide, please. I'm going to talk a little bit about what the board is seeing with what we can only assume is due to the use of AI. So we all know that normally we hear the term hallucinated cites when AI is used. In some of our cases, we're not necessarily having people fess up to using AI. It could just be that they're not checking what they're submitting to us. And so I went with the term fictitious, hallucinated. You can call them fake, you can call them bad, but the issue is the same. We're seeing legal briefs and motions that include cites to non-existent cases, made up quotations, and misstatements of what cases say. And that's a problem. And so I do want everybody to be aware, this is the lawyers of you out there and any of our pro se parties, the USPTO's existing rules apply broadly, and it's regardless of whether any AI assistance was used in preparing your submissions. Rule 1118, it says that by presenting to the office, whether you're signing, filing, submitting, or later advocating any paper, you, the party who are presenting it, is certifying the truth and accuracy of the submission, and that to the best of your knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, that you're not presenting the paper for any improper purpose, the legal contentions are warranted by existing law, and your factual allegations have evidentiary support. So what does this all mean? It means that you're under a duty to verify the accuracy of the legal cites in your submission to us before you file it. And again, this is true regardless of how the submission was prepared. And I will say that assuming the accuracy of an AI tool is not a reasonable inquiry. AI tools can, as we said, spit out things that are not right, misstate the law, hallucinate cites. And so if you do use AI tools, because we fully recognize their benefits to trying to make things more efficient, just use them in a responsible manner and always verify the accuracy of the output. So again, before you submit any motion or brief to the TTAB, please make sure you go back and check that the cases you cite exist and that you're accurately representing what they say. Our decisions, the TTAB's decisions, are available for free in the TTAB reading room. It's available on the USPTO's website. You can search them by name, topic. So it's a free resource for you to find our decisions. Not every single one is in there, but I think we've got all of the precedents going back pretty far, and then any of the non-presidential final decisions since about 2006 forward. So again, and you can filter by the precedents. We'd prefer that you only cite precedents to us, but all of our decisions are there if you need to check whether a decision actually exists. So we encourage you to use that resource. They are also available through services such as LexisNexis and Westlaw and Bluebird Law. So what happens if you don't check the accuracy of your cites? Well, we can impose sanctions, and we do, and we will. We have various authority to impose sanctions, including under 1118, Federal Civil Procedure Rule 11, and we also have inherent authority as the board to manage our own proceedings and control what happens in them. And sanctions can include striking the filing and entry of judgment. So just as an example, next slide, please. We had a case last year where a party cited case law that was non-existent, misquoted, didn't support their arguments. The attorney admitted that he hadn't actually read the brief or attempted to look up the cites. His brief was stricken. He was referred to OED, and OED disciplined him, and then his state par did reciprocal discipline. So there are real consequences to this, and we just ask you to please do your due diligence and check the accuracy of what you file with us. Next slide, please. So again, to avoid missteps, verify before you submit. And if you're a party to one of our proceedings and you see that your opposing party has filed something that has fake case cites or other problems with it, I would encourage you to reach out to the interlocutory attorney that is assigned to your case. It's a waste of everybody's time if this goes through for too long, where you're responding to a brief or we're having to siphon through and check these cites ourselves. which has happened in a recent case where nobody raised it to us, but we found this issue. And it's just better if we are, notified of it early, and then we can figure out how we might deal with it. And if you are a party who realizes, whoops, I submitted something that I didn't check, or that I realize now I put some bad cites in there, or I just made a mistake with the citation, because again, this happens even without AI. You might have copied and pasted from something and it's a wrong site, and there was no kind of AI involved in the process. Come to us, ask to have it withdrawn, ask to have it resubmitted early. It's if you wait and it goes through the process, that's when that's sanctionable. And so again, just some kind of tips to avoid the typical risks would be my suggestion there. So the other thing that we have seen, and this was a new one, we have discovery conferences. Those of you who participate in our trial cases know that, with our interlocutory attorneys. They will have discovery conferences with you, and those are meant to be a place where you can freely share your thoughts and resolve issues. Our rules specifically prohibit the recording of those conferences. That would extend to AI chatbots that you might want to invite to join to transcribe the meeting. That's a no-no. We had that happen recently. There's one called Maestro. Somebody invited Maestro. We kicked Maestro out. So please do not do that. And then this is a good transition over to Jill to talk about some of the trial case issues that we've been seeing, and particularly ACR and our pretrial conference program. So with that, I will turn it over to Jill.
As Judge Heber mentioned, I'm one of the interlocutory attorneys here at the board. And as some of you may know, we handle a lot of discovery related and other pretrial issues before cases get turned over to the administrative panel, the panel of administrative trademark judges that ultimately address the merits of the dispute. And one of the issues that we often handle in conjunction with the parties is something called accelerated case resolution. And internally here, we will refer to it as ACR. Next slide, please. So ACR is really an umbrella term that refers to any number of alternative procedures or stipulations that parties can voluntarily adopt in their proceedings to try to streamline their case. And we have learned over time that if parties adopt ACR, they may save both time and money. They can avoid costly discovery disputes, eliminate or at least narrow evidentiary objections at trial, or even potentially, if the parties are willing, avoid a trial phase altogether. So these stipulations also can reduce the size of the record before the board, which not only helps the parties to focus on their best evidence for their claims or their defenses, but it also helps the board and allows the administrative trademark judges to review the record more efficiently and issue their decisions more efficiently. So parties who are interested in accelerated case resolution have a number of options available to them. First, they can review the board's manual of procedure for additional information. And if I could here today impress upon all of you just one thing to take away from today, from the perspective of an interlocutory attorney, it would be to read the board's manual of procedure. We refer to it as the TBMP. You can find it online through a Google or Bing search or whatever search engine you may use. And the manual is text searchable. So it's a very useful resource for practitioners or pro se parties. And it has an entire section about accelerated case resolution. Another option that the parties have is to request a conference with their assigned interlocutory attorney to discuss ACR. And we do that frequently, where we can work with the parties to figure out if ACR is something that may be beneficial to both parties, and how you can go about actually implementing ACR in your case. Next slide, please. So when we talk to you about how you may best implement ACR, there's a couple of factors that we will consider. The most common form of ACR here at the board is what we call summary judgment style ACR. And what this is the parties will submit summary judgment style briefs and attach their evidence to those briefs. And they will tell the board that the judges can adjudicate genuine disputes of material fact as part of that briefing process. And so under this portion of ACR, or this approach to ACR, the parties avoid the trial period altogether. That is probably our most common form of ACR. It is oftentimes implemented after a normal motion for summary judgment is denied because the board finds genuine disputes of fact. But there are other options of ACR available to the parties, including stipulations of fact, stipulations to limit the discovery period, maybe limit the amount of discovery requests, which are formal requests that the parties can exchange, wherein you're asking for documents or maybe depositions, and you can limit that. You can also enter into stipulations on admissibility of evidence at trial to reduce the number of objections that the parties raise and that the board adjudicates. So there are a lot of options available to the parties, and we encourage the parties to consider ACR when they are before us. It's not going to be applicable to every case. It's not appropriate in all circumstances, but it can be a very efficient way for the parties to streamline their case, save time and money. Next slide, please. So similarly, but different, I'd like to next talk about the pretrial conference pilot program. Next slide. Thank you. So the pretrial conference pilot program is a program that we commenced here at the board in 2023 in an effort to save time and resources for the parties and the board, and also to foster the most effective and efficient presentation of cases. The pilot is not intended for all cases. In fact, I would argue it's not intended for most. But we do have a committee here at the board that looks at a number of factors when considering cases for this pilot, including how many claims and defenses are there involved in the proceeding? What's the size of the record? For example, have the parties submitted summary judgment briefs already that had 5,000 more pages attached as evidence to their summary judgment briefs? Has there been a complicated procedural history of the case? Maybe there have been a number of civil actions between the parties in addition to their board proceedings because they are involved in a global trademark dispute. That's something that we see quite regularly here at the board. So if selected, the parties will be called in over the phone for an initial conference with an interlocutory attorney and an administrative trademark judge who will discuss the pilot, provide some background to the parties. And then after that initial conference, the parties will work together to create a pretrial conference order with instruction from the board. And that pretrial conference order will then govern the trial moving forward in the proceeding. Next slide, please. So just to give you a little bit more about the procedure of how the pilot works is typically around the close of discovery, although as it is a pilot program, it may vary by case, but typically around the close of discovery, we will issue an order notifying the parties that they have been selected for the pilot and tell them why. And we will have that initial orientation conference with them. And then we will provide them instruction for how to go about exchanging their proposed final pretrial conference order. In that order, they will exchange lists of potential witnesses and exhibits. They will write a summary of the claims and defenses that are still at issue in the proceeding. And then they will file that order with us, which we will review and have a final conference with them to discuss any tweaks or issues that need to be addressed. And then the board will issue that final order and it will govern the trial moving forward. Next slide. Just to give you a brief overview of the last fiscal year, which as Judge Johnson mentioned earlier, ended on September 30th of 2025. We currently have 9 cases that are active in the pilot. They are all at different stages of proceedings. There are 5 oppositions and 4 cancellations. And we did also have 2 pilot cases that resolved by way of settlement in that time period. And we have found that one of the benefits of the pilot is the parties spend the effort to go through and figure out what is the most pertinent evidence in their case, who are the most relevant witness, what are the most important claims and defenses. And that has been helpful for both the parties and the board as we go through this process. Next slide. So as I mentioned, the goals of the pilot are to save time and resources for both the parties and the board. And also to encourage the parties to potentially resolve extraneous claims and defenses, or to limit objections that are not case dispositive, and to enter into other stipulations of fact to allow them to really focus their briefs and the evidence of record on the most important issues that they want the judges to focus on when adjudicating the merits of the dispute. With that, that is the information that I had on the pretrial conference pilot. And I believe our next slide, we were going to go through some of the questions about pretrial and discovery issues that came up from the last USPTO hour that the TTAB conducted back in May of 2025. So I will go through, these are not all the questions, but some of the ones that we felt that were most pertinent to issues that we see in our trial cases most regularly. Next slide. So first, we received a question about motions to strike pleadings, which was, at which point can you file a motion to strike a pleading? Is it only after an answer or counterclaims, or are there other points in time where it can be filed? So this is a great question. We here at the board, not always, but in general, follow the federal rules of civil procedure in our trial cases, which allows a motion to strike a pleading to be filed within 21 days of the service of that pleading. However, there is some discretion here at the board to allow a late filed motion to strike a pleading. And also the board has the authority to sua sponte review and strike a pleading or sections of a pleading in the event that it would be beneficial for the case for the board to do so. Next slide. The next question that we received related to requests for extensions or suspensions of the trial period. This actually comes up quite frequently, so it's a great question. If the board grants an extension or a suspension of the trial schedule, will this automatically extend the deadline to respond to outstanding discovery requests, or does this need to be agreed upon by the parties? As I mentioned before, in our opposition and cancellation proceedings, parties have the option to exchange discovery, either be it written discovery requests or requests for deposition, etc. And the interlocutory attorneys will often handle disputes that arise during that discovery process. So the answer to this specific question is no, that if you only ask for an extension of the trial schedule and don't request an extension of time to respond to discovery requests, then that deadline to respond to those requests is not part of the order of your request for extension. But I think that the question raises really a broader point that I think is a helpful tip for practitioners before the board. Please put the relief that you are requesting in your motion. We can only you know what it is that you're looking for in your motion if you put it in there. So I always strongly encourage the parties to include the relief that you are requesting in its entirety in your motion so that we can properly adjudicate it and ensure that our order gives the parties the relief that they are seeking. Next slide, please. Thank you. And the last question we had, similarly, is a very specific question, but has some sort of broader implications for our practice, which is when a TTAB proceeding is suspended, should we continue to wait for the new schedule? For example, we don't need to serve initial disclosures if proceedings are suspended. And so for this, I would say, please read the suspension order that issues in your case. Oftentimes, if the board issues a suspension order, we will tell you that proceedings are suspended for all purposes except X. X may be consideration of your pending motion. It may be the exchange of expert discovery. So there are a lot of different reasons why the board may suspend your proceeding during discovery. But I would strongly encourage you to really review that suspension order because it will tell you if anything that you should be continuing during the suspension phase. But in general, you know, with the caveat that there may be exceptions, generally, if the proceeding is suspended, you do not need to exchange and continue on with the schedule unless the order expressly tells you that you should do so. And that is the close of the questions on my end that I wanted to walk through. So I believe I'm turning it back over to the judges for the remaining slides.
Yeah, and I believe that our remaining slides are really just some resource links for you to find some of the things like Jill had mentioned, the Trademark Board Manual of Procedure. I did see in the chat that there was a request that we post the link to the nomination form for precedent decision. So I will leave that to our tech people hosting this to see if we can do that. If not, we will certainly send it to you separately. One thing before we turn to the resources, and I'm not sure if questions have come in that Jason has for us, that I did want to mention that I had not mentioned earlier as an update. For those of you who file with us regularly, you know this already. For those of you who don't, we are transitioning our platform to TTAB Center. So that TTAB Center is going to be the one-stop shop where you file everything with the TTAB. Currently, right now, you file opposition, so notices of oppositions and petitions to cancel using TTAB Center, and we still have ESTA going for all of the other filings. You will be seeing probably within the next month that a number of the notice of reliance and evidence filings will be transitioning over to TTAB Center and away from ESTA, and everything should be transitioned over to TTAB Center by about June of 2027, if not before. And TTAB Center has a lot of advantages over ESTA, but one thing that I want to flag for you is that it does require myuspto.gov login. So if you are planning to file something with us, or you have, for example, evidentiary filings coming up in a case, and we do that transition over to TTAB Center, and you have not yet gotten yourself a myuspto.gov account, I strongly encourage you to do that so you won't have any issues being able to submit your filings with the board. And with that, I think I'll turn it back over. I guess we can show the resources slide, but then Jason, I'm not sure if there were any questions of general interest that had come in or not.
Oh, yes. There are always questions. Our attendees always really have fantastic questions. We'll do our best to go through as many as we can before we have to leave today. So yeah, if we could just continue to leave that slide up there. I think there are 2 slides of resources. So Roman, maybe after a minute or 2, you could also advance to the next one, just so folks have an opportunity to check out some of those links. And for those of you who are interested in links, make sure you open up the chat. I threw some in there. Thank you, Stacy, for that question about the TTAB presidential nomination form. That is in there for you, along with some additional links that hopefully you'll find helpful. Also, just threw in the one there for TTAB Center. Yeah, USPTO wide, we're transitioning to these centers. It's coming, and please hop on. It's a fantastic freight train. Please go ahead and start using the various centers for all the various things that you might be doing, at least the things they have capability to do. It's really kind of exciting. We're kind of creating these one-stop shops for the various business units across the agency. All right. Well, first of all, wonderful job. Thank you, folks, so much. Great job on that presentation. We have about 14 minutes left, so we'll try to get to as many questions as we can. So one of them, here's a fun one from John. Maybe one of you could say, who is the judge that recently retired? I know we have a lot of TTAB watchers who are probably here today and are curious about who's up and who's no longer with the board. Anybody want to handle that one? If you don't know,
I believe it was Al Zervis who most recently retired.
Got it. Okay, cool. Well, there you go, John. Hopefully that helps you.
And I should also say our former Deputy Chief Judge Tom Shaw is the most recent. He retired at the end of the year. Yeah.
Yes. Okay, good. Well, thank you very much. Good. All right. Well, we have a question here from Christine, kind of an interesting one here. If a precedential decision is overturned, is there something changed on the face of the decision, or is it just up to the bar to confirm if the decision has been overturned? I mean, when I read the cases anyway, sometimes I'll see this has been marked as precedential. And so does that change at all if something's overturned?
We do not make any changes to the decisions. I honestly do not know what the reporters do, but I would imagine it's kind of like anything else. If we had a precedential decision that went up to the federal circuit and they reversed it or they vacated it, that should be reflected in a subsequent history if you're checking on one of those services. Otherwise, I think you would need to check it on your own.
Okay, great. Sounds good. Let's see here. We didn't have a ton in here. Okay, yeah, Stacy, I got you with regard to the nomination form. So there we go. Interesting question here from Ashma. And again, we don't have to, reveal too much behind the curtain because I know that, there are some things we can and cannot say. But Ashma had a question about any tools that we might use or something like that to identify invalid citations or something that might be AI generated. And it's totally fine if we don't have something or that if we have something we can't talk about, that's okay too. But certainly some interest in terms of how are we determining whether something would be a fictitious citation or hallucination citation.
Yeah, I mean, we don't have a tool right now. I do think that's something that we would like to see. I understand this problem is not, limited to the TTAB. I think the entire agency is having some issues with it, and we're exploring what tools might be available to help us potentially screen incoming filings. But there's nothing that we have here on deck yet, other than, our judges and attorneys, when they're reviewing the brief or the motion that's filed, and you're saying, hey, TTAB, you didn't follow this relevant precedent. And we look at this case and we're like, well, we can't find that case anywhere. Or this name of this case exists, but it's not at the site you gave us, and it doesn't stand for what you said it stands for. And so that's a real time-consuming process. So it's human, it's slow at the moment is how we're detecting it. But I do think we'd be certainly interested in finding some tools that would help us do it faster.
Okay, great. Yeah, I think it's going to be interesting to see that shift over the next couple of years because the USPTO in general is interested in integrating AI into our various processes, whether from the patent side, also on the trademark side, to see where it can help make us more efficient. So cool. Yeah. This could be one of those opportunities right here. Okay, good. Until then, of course, it's just hardworking humans until we pit the robots against the robots, and then we'll see what happens. All right. Well, we had a question here, somewhat similar perhaps to Christine's question. This is from Nasser. While newer cases explicitly state whether they are precedential, Some older cases do not necessarily make it clear. Is there another way to confirm whether a case is precedential? And I'm not sure how back Nasser is talking about here, and it's okay if you're like, well, it was in 1976 when we transitioned it. That's fine. But any thoughts on that for helping folks distinguish whether or not an older case happens to be precedential?
Yeah, I will say I can't speak a ton to the real older cases. I do know that the United States Patent Quarterly, USPQ, which is where all of our decisions used to be published and were only available, they sometimes published ones that we did not designate. So the fact that it's in the USPQ doesn't necessarily mean it was binding. So I apologize. I don't have a very clear answer for you on the older ones. I will say that the newer ones are very clear. And it should be clear in any service that you use. It'll be clear on the face of our decision. And by newer, I mean like going back probably almost 30 years now. And so, yeah, there's definitely going to be older cases that maybe say some things that are helpful, but by and large, I would imagine that we have more recent precedent that probably, says the same thing or reinforces a principle. And so hopefully you're not having to take a deep dive back to, say, 1960s cases. But if you do, again, you're allowed to cite non-precedents to us. They're not binding on us. We don't have to follow them. But if you're having trouble, I would suggest trying to find the same principle in a more recent case might be one way to handle that.
Okay, great. Thank you. All right. Well, we had a couple of other questions that we have here. And again, this is open to anybody here. Will the judge who participates in a pretrial conference also be assigned to the final decision? Jill, you want to take that? Yeah.
I can feel that no. The short answer is no. And the parties would be advised of that. As I mentioned before, we have a initial conference with the parties where we talk to them about the pilot, and we explain that to them as part of that conference, that the judge who participates in the pilot program will not be assigned to the final panel of judges that adjudicate the merits.
Okay. So my screen froze up, so I apologize if I dropped out there for a second and did a little max headroom for you guys. But I should be back. Okay. So here's another question, and again, this is we could have a little conversation about this as well. Do you have any tips?
Oh, you cut out for us, Jason.
He's frozen.
Okay, well, while he's frozen, I'm gonna say something else on citations real quickly. Two quick things on precedent and redesignation. I do want to be clear that we listen to you, we hear you. We had seen that there was a decision we issued in November where we saw several comments saying this would be a valuable precedent. And we just redesignated it yesterday, right? So, we are open for sure to hearing from you on these things and your reasons for why. On citations, some of you may know that we had a citation pilot program running for a while. The agency, by and large, lost access to the USPQs. And so if we can't easily look them up, right, we need to find another way. We shouldn't be citing to them either. And so you will see in our decisions that now we list our proceeding number, whether it's the appeal or the opposition or the cancellation number. Our citation format will lead with that if that number is available, so that you could go find the decision in either the reading room if it's a final decision, or in TTAB view in the particular case proceeding if it was a decision on an order. And then we'll follow it with either a Lexis or a Westlaw citation. So, do not feel like you need to be citing USPQ to us anymore. We are perfectly happy to have you cite Westlaw, Lexis, or our own proceeding number. And so I just wanted to let everybody know that as well. And now it looks like Jason is back. That was good timing. So
Oh, technology. Technology is always great. My guess is the robots probably heard me talk about robots versus robots, and that's why they kicked me out. Okay, so what before I get kicked out again, I see a note here in the chat for from Tina asking for part 1 of our series. This is for you, Tina. I'm throwing it into the chat if you want to go back and watch the first part of our intro to the TTAB. So that's in the chat for you right there. Okay, we have about 5 minutes. Hopefully my internet connection will remain stable until then. So maybe some things that you all have seen over the years. Some tips for folks, whether they're perhaps writing a brief or they're thinking about they're getting ready for an appeal or for a trial case. Maybe just like one sort of pro tip for the folks that you could pass along as an action item that they could keep in mind. We're looking, experiences that you have had. You're like, what would be better is if people did this.
Well, I'll take that, Jason, first. First of all, I want people to focus on, we had a slide in our first presentation for 5 do's and don'ts. You can rehash and look at that, our presentation from May 2025. But Attorney McCormick already said, please follow our Trademark Trial and Appeal Board manual, the TBMP. The last edition is June 2025. We really encourage that you look at that and follow our rules, because one of the things that really upsets judges is when people don't, when the page numbers are wrong, when you submit evidence that is duplicative without any page numbers or with page numbers. It just slows down the disposition of your proceeding, because the judges have to go through all the evidence of record that's submitted. Nobody else does it. You don't have law clerks that do it. We do that. So please follow our rules in the TBMP. It'll make things a lot more, make things go a lot more smoothly. And then I just have one tip for oral hearings. This is not oral hearings, or hearings are not the time to introduce new arguments that you haven't put in your briefing or new evidence. Present your top 3 or your strongest arguments, just like you would present to a court of law, and also answer the judge's questions and be able to point to evidence in the record to support your arguments. I think we see a lot of parties who aren't able to point to where the supporting evidence is. So those are my tips.
And I'll add on to that, focus on the evidence point, is that our cases are 100%, fact findings are 100% based on the evidence that is in the record. Time and again, we will see, and I see it at the, when I defend the board's decisions outside of the agency, attorney argument is not evidence. And so if the board has to decide it based on the evidence that they have. So I would encourage you, if you think an examining attorney got something wrong, or your opposing party is saying something, you need to counter that with relevant evidence. The board cannot help you out there. And if you don't, then we kind of have a one-sided evidentiary record, and just saying things as an argumentative way without any support for us is not something that we can really rely on for you. So that is another tip I would say. Really build your record, build the strongest record you can, so that we can evaluate that and issue a decision.
Excellent. So, Jill, we are almost at time, but is there anything that, any like lightning round quick tip that you can think of you'd like to provide to the folks? And it's okay if not, so.
Sure. Obviously, my tips are going to come more from the pretrial perspective, since I'm an attorney and not a judge. But if I could give one, it would be, please make a good faith effort to resolve your discovery disputes before you come to us. Obviously, we recognize everyone is zealously advocating for their clients. Sometimes there are legitimate good faith disputes that you need board intervention to resolve, but we do have a requirement that you have to at least make an effort to resolve them yourselves first. at a minimum, maybe you can streamline and reduce the number of topics in dispute. It really does help you focus on what's most important, and it helps us resolve your motions faster. So.
Excellent. I love it. I think it's always helpful when we have the tips coming from different perspectives, whether it's from the judge level, for the interlock perspective. I think it's all helpful for the folks. Thank you very much. All right, it is now the top of the hour, which means that we need to close out for today, unfortunately. But I want to give a big thank you to our experts who are here today. We have, let's see, Acting Chief Judge Heber, Acting Deputy Chief Judge Johnson, and of course our interlocutory attorney here, Jill McCormick. Thank you so much. We have a great team in the background helping out. Despite my internet issues, they were doing everything perfectly. So big thank you to all those folks, including Linda, the captioner. And of course, a big thank you to you folks for hanging out with us for an hour for our introduction to the TTAB Part 2 and updates. We look forward to seeing you next month when we'll be back for another USPTO hour focusing on trademarks. You can always look for us typically on the 4th Wednesday of the month, and we hope to have another great topic for you to help you along. So thank you again, folks. Have a great day and take care.